I've got a great topic for you today, and that topic's this. So let's assume I'm charged with just blowing over the legal limit, like blowing 80 milligrams of alcohol in 100 milligrams of blood over that, or over, okay? I'm not charged with impaired driving. So the question is, do I have to testify, or do I need to testify, is the more proper question, at my trial? Well, it's a bit of a loaded answer to that, and a loaded question. In most over 80 cases, it's always a technical defense, right? That you're trying to show that the police did not do step A, B, or C correctly and get the case thrown out. It's a very complicated area of law, and the police often do make mistakes. So for that type of defense, it's not about the accused supplying the mistake, it's the defense lawyer cross-examining the police to show they've made that mistake. So for that type of over 80 type case where you're exposing a deficiency, the accused wouldn't have to testify at all. So that's great. It makes it a lot easier because you don't have to prepare your client to testify. Now, there are situations in an over 80 trial where you need to bring a charter application. It might be a right to counsel application or reasonable and probable grounds application, which I covered in other videos. In those cases, your client may or may need to testify on the pretrial application. It just depends. In many rights to counsel applications, it's necessary for your client to testify. It's more rare in an RPG, reasonable probable ground application. In that case, usually not, actually. So there are certain charter issues that we file that go along with the trial that take place at the beginning of the trial, where they do have to testify. For most 80 and over cases, though, where there's not an impaired driving child, the accused does not have to testify. There are still a few positive defenses where they might. I'll give you an example. The accused is testifying that they drank after an accident, for example, and are trying to show that they were below the legal limit at the time of the accident. They went home, for example, and started drinking. So there you have it. The beauty of doing a lot of over 80 cases is the accused often does not have to testify, so it relieves that stress. You're just looking for a mistake that the police make that you can expose and create a reasonable doubt. And many of these cases can be won on that point. Many of these cases can also be won arguing charter issues where the accused often has to testify, but certainly not in every case. So there you have it, the short answer, hopefully, to whether an accused needs to testify at an over 80 case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.